Thank you so much, everyone, for coming here. I know that this is a very important session, um, and we are so ever so thankful to Attorney Hopwood. This is the ACP session hosted by DC, Maryland from the East Coast, and Washington State from the West Coast. So it's a merging of both the coasts here. And we are delighted to invite all the members from all these states to attend this really informative session to be given by Attorney Hopwood, who, in spite of being really sick, has been so kind enough, drinking a lot of tea today and coming and giving us this session. So we are ever so grateful to you. Attorney Hopwood earned a law degree from the University of Connecticut School of Law, and she is a partner in immigration practice, group leader at Carmody, Torrance, Sandak, and Hennessey LLP in Connecticut. She has particular focus on representing academic teaching hospitals and federally qualified health centers in sponsoring IMG physicians for both the visa and the green card level. So, what an expertise. So, she brings this valuable experience in helping many IMGs navigate the self-petition and other immigration pathways to as they work towards building their professional futures and achieving the American dream, which is still there. And thank you so much, Attorney Hopwood. Just one thing I would like to say is we're going to have a 45-minute session. Attorney Hopwood is going to talk. And meanwhile, if you have any questions, please put it in the chat. We are going to have a Q&A session in the end. So that is what is going to happen. And everybody is going to get muted other than Attorney Hopwood at this time. So thank you all for joining. And let's go ahead with the session.
Great. Thank you so much for the warm welcome. It's nice to be here with you this evening. We find ourselves in an era of unprecedented immigration restrictions and enforcement under the current administration. Anxiety levels, as you're all aware, are understandably very high, and many foreign nationals who are currently present in the US in legal status are suffering the consequences of being subject to the myriad of new restrictions that have come down the pipeline. So, tonight we'll walk through what some of those new restrictions are and discuss the negative impacts they're having on IMGs in order to get a better understanding of the framework that we're working in. We'll then discuss some strategic steps that you can take in connection with self-petitioned green card filings as a potential mechanism to become a lawful permanent resident sooner rather than later in an effort to circumvent what's becoming an increasingly challenging landscape in connection with visa sponsorship. While some IMGs may not be able to file for adjustment of status and become lawful permanent residents in the near future, perhaps due to needing to fulfill their 3-year J1 waiver commitment, or perhaps due to being a national of a backlogged country like India, it's very important to start strategically thinking about what the most efficient way and path will be to obtaining a green card. That way, you can start working on strengthening your CV by taking concerted action if you're going to pursue a self-petitioned green card. Or alternatively, you can start trying to align employer-sponsored green card sponsorship so that you're not faced with a situation where you're running out of, let's say, H-1B time because you're approaching the 6-year maximum period of stay. So it's really about planning and preparing so that you are well positioned to protect your ability to continue working without disruption and maintain your work authorization, and hopefully get to that point where you can obtain a green card and no longer have to jump through all these hoops and hassles and headaches that we know are involved with these processes. Just a quick disclaimer before we dive into the presentation. The contents of tonight's presentation do not constitute legal advice, and you're strongly encouraged to engage the services of your own independent immigration attorney for consultation purposes to discuss the nuances of your individual circumstances. And as Chinaki referenced, we will reserve time at the conclusion of the presentation for you to ask questions, because we're hoping this will be as informative as possible, and we can address as many questions and concerns as that you may have. All right, so let's jump in. First, as I mentioned, we're going to focus on what some of the new restrictions are that have come down the pipeline in the last year or so that are really impacting the landscape of visa restrictions for IMGs, and are really quite affecting even, institutional policies, et cetera. So first topic that I wanted to cover, first update, which a lot of questions from not just the IMG employee beneficiary side flowed through, but also from employers. There was a flood of questions in connection with the announcement of the $100,000 H-1B filing fee. So now I think, most people are somewhat generally aware of when this fee applies and when it doesn't. But I wanted to walk you through what the framework is, just so everyone has an understanding of who's affected and who's not. So this new 100K filing fee primarily affects consular processed filings. And really what that means is it pertains to H-1B filings for prospective new hires who are currently located overseas and need to consular process to get a visa stamp before coming to the US. It does not impact individuals already in the US in valid H-1B status, in connection with, let's say, changing employers. If a new employer wants to file an H-1B change of employer petition, the 100K fee does not apply. It also does not apply for H-1B extensions with the same employer. Similarly, but actually different for individuals that are currently in another valid non-immigrant status present in the US who are eligible for a change of status. So the hypothetical scenario that I'll present is someone who is here, let's say going to medical school on an F1 student visa, who may start working pursuant to OPT work authorization, who is filing a change of status to H-1B from within the US. The 100K fee does not apply in that scenario. So really the crux of it is if someone's here in the US in valid non-immigrant status and can either extend their status, change employers, and effectuate that from within the US, the 100K fee does not apply, as I mentioned. Despite that fact, so really taking a step back, this new fee really has had quite the impact, I would say, on the institutional policies of academic teaching hospitals that have robust graduate medical education training programs, and has affected their visa sponsorship policy with H-1Bs for incoming residents coming from overseas. Because of course, the hospital cannot be on the hook 100K a pop to sponsor, residents to come in from overseas. So I represent academic teaching hospitals that previously supported H-1B visa sponsorship for their GME program, that have had to change their policy and shift to J-1s instead to for the new incoming residents coming from overseas in an effort to avoid the application or applicability of the 100K filing fee for H-1Bs. So I do think this is going to create a significant shift in that specific context to more resident physicians doing their training on J1s versus H1Bs, because it seems to have been a very widespread policy shift amongst the large academic teaching hospitals. Um, the other implication of the 100K filing fee that I've seen play out, particularly because our practice files a lot of J1 waiver applications for J1 trainees who need to waive the 2-year home residence requirement. For those that start the J1 waiver process late, and it's a very slow process, further exacerbated by a lot of the current administrations. Initially it was the DOGE cuts, so employee cutbacks of the federal agency level. A lot of the J1 waiver programs, off the top of my head, particularly HHS waivers, that's a federal agency that has been severely impacted by the multitude of government shutdowns that we've all had to um, endure. So waiver processing times are at an all-time, you know, I would say slowest processing time since I can remember. So it's really critical to start the J1 waiver process as early as possible. Now, how does this all relate to the H-1B 100K filing fee? Well, for those trainees who need a J1 waiver, once the waiver is approved, ultimately an H-1B change of status application needs to be filed. Um, in order to file that from within the US and get it approved, the trainee needs to maintain their J1 status through the filing of the H-1B change of status application. If they run out of J1 time before the waiver is approved and the H-1B subsequently can be filed, that change of status request, they would have to depart the US to avoid accruing unlawful presence here, not being in valid J status. And as soon as they run out of that time and have to depart the US before they were eligible to file for the H-1B change of status, that departure from the US would then trigger the 100K filing fee. And employers are not supportive of filing that fee for obvious financial reasons. So for that reason, I mention this to highlight the importance of trainees on J1s that need to file for J1 waivers, starting that process as early as possible. So for a traditional IM residency training program, looking for that waiver job at the end of the PGY2 training year, so that come fall of PGY3 year, the waiver application is in the queue and being filed, versus, what I'm seeing now is some employer clients of mine are initiating J1 waiver requests and it's April. And there's really not enough time right now to get the waiver approved before a graduating resident's J1 status period would expire. Most of them expire, June 30th. And even with an extension to take the board exams through August, tack on the 30-day grace period from there, which brings you to the end of September, it's still taking sometimes 6+ months to get the waiver application approved. So that is something to be mindful of. Let's move on to the next restriction that I wanted to cover, that I see having a really significant impact, and that is travel ban restrictions. So there's different travel ban restrictions in place. One was the initial one, which essentially there's 19 full ban, what we call red list countries, and now up to 20 partial ban orange list countries. When the travel ban rolled out in its first iteration, really this travel ban was only affecting non-immigrant visa applicants and immigrant visa applicants that were consular processing overseas, which is not the majority of people that, not concerning the people who are already here in valid immigration status. So we were seeing some ripple effects, but really not a significant impact on those kind of consular processing level travel and visa restrictions. What we're seeing now that really is having a significant impact is for the all of those travel ban list country nationals. So it's the red list and the orange list, which total almost 40 countries. USCIS has now put a adjudications or processing hold on making decisions on any type of immigration benefit filed with USCIS if you're from one of those 40 countries. So um, we're seeing some very significant effects based on that USCIS adjudications hold. There are supposed to be national interest exceptions for both the 100K filing fee and also for this adjudications hold with USCIS that I just referenced. Problem is, USCIS is not adjudicating any of the NIE requests. They're just simply not making any decisions. So no one is getting any headway, even if they have a compelling NIE exception to present. Those approvals have not been forthcoming. So for the USCIS processing hold, it's just a complete stall out on applications for those individuals from the travel ban list countries that are pending with USCIS. Just last week, the first NIE decisions in connection with the 100K filing fee started rolling out. Now, granted, that waiver email inbox for applying for those NIEs was created by USCIS back in October. So now we're in April, and only in the last week, USCIS is rolling out its very initial NIE denials for exceptions to the 100K filing fee that were filed for right in the infancy of that program being instituted. So October denials are just starting to roll in April. And from what we've heard from, my colleagues throughout the United States who practice physician immigration law, for what we thought were compelling NIE cases, USCIS is just issuing boilerplate denial, saying it's not in the national interest. So it's not, it's looking more dismal with the NIE exceptions than anyone had hoped for. We're also, seeing the implications of this while individuals are being able to timely submit H-1B extension requests. If they do submit before their current H-1B expiration date, their employment authorization is automatically extended for a period of 240 days from when their last H-1B expired. But what we're seeing is USCIS processing times are so slow that we're coming up against the 240-day mark of when the automatic employment authorization expires, and decisions have not been made. And when a premium processing upgrade request is made to USCIS to try to prompt a decision within the 240-day mark, USCIS is not adjudicating those for these travel ban list countries, putting individuals and employers in a very difficult situation whereby really the employee is not authorized to work past that 240-day mark and is unable to obtain an approval basically because of this processing hold. We're also seeing this with EAD initial requests and or renewal requests for travel ban list nationals as well, where someone who's not automatically eligible for an EAD extension or it's only for a prescribed amount of time and then that time elapses. Um, that's also a scenario where, individuals are looking at potentially running out of and having a disruption to their employment authorization because of this USCIS processing hold. So, the reason why I mentioned all of that is because it really shows you how challenging the current framework is for everyone who, the IMGs who are here on visas. It's a minefield with all these various restrictions, and so that makes it, increasingly more important to hopefully obtain a green card as quickly as possible, because when you become a lawful permanent resident, um, many of these visa restrictions, processing holds, etcetera, are not going to impact you anymore. So that really brings us to the second half of the presentation, focused on what are some strategies that can be considered in connection with self-sponsored green card filings. With all that in mind, because it will be increasingly become a priority, I think, for IMGs to try to get green cards as quickly as possible. So the traditional employer-sponsored green card process, which is referred to as the perm application, is very slow and requires a permanent offer of employment. By permanent, I just mean a long-term position, not of a defined short-term duration, which GME training program positions are. So for your residents and fellows who are doing their training and they're in a program for a prescribed period of time, the employer can't sponsor them for a perm application because it's not a long-term permanent position. Um, Even if they could, the perm application process is incredibly slow. It typically takes almost a year and a half to essentially jump through all the hoops that are involved in conducting the required recruitment and advertising that the government mandates to prove there's no qualified U.S. workers for the position being offered. So not only is it not feasible for certain individuals, depending on the nature of their job position, it's also incredibly slow. Um, on the other hand, self-petition green cards can be quicker in processing. Why? Because essentially you skip the entire perm application process and you go straight to the I-140 petition phase, which saves an incredible amount of time. Um, Additionally, with I-140s, they are premium processing eligible. So typically, within filing the petition, a decision can be obtained within 45 days. Um, that is a great thing if someone is looking to make their let's say the primary applicant's on an H-1B and they have an H-4 spouse who would like to obtain work authorization. H-4 spouses are only eligible for work authorization if the primary H-1B visa holder has an I-140 approval. So it's great to go right to filing the I-140 with premium processing and get a decision within a couple of months of filing, and then be able to turn around and file for an H-4 EAD. Um, Furthermore, it really saves a lot of time in terms of sealing in one's priority date, because under the perm context, the priority date is not determined or sealed in until the perm application is actually filed with the Department of Labor electronically, which, as I mentioned previously, can take upwards of a year and a half. Um, sorry, I will backtrack. Now it is better. One of the preliminary steps of a perm application is getting something called a prevailing wage determination from the Department of Labor. The processing times were so long for that, probably 6 months ago. They were upwards of 10 months, and you need to get the prevailing wage before filing the perm application and completing the last step. So it was really taking, at least a year before you could file the perm. When you file the perm, the priority date is sealed in, but them taking the DOL up to a year or more longer to process the perm filing. So as you can see, that process is incredibly slow. With filing the I-140, the priority date is sealed in upon filing, therefore making it a shorter wait time start to finish for green card eligibility. This really is a major benefit for individuals from backlogged countries, as per the visa bulletin, per country specifications. The sooner you can seal in your priority date, the shorter the ultimate wait time. Even if it may be an incredibly long wait, you're chipping into that a lot faster. The other thing to consider in the self-petition green card context is um, fin- I wanted to touch upon the financial responsibility typically for these filings versus the perm sponsorship financial responsibility and who that falls on. For perm applications, the one real benefit of it, because I've really hammered home some of the cons in terms of it being a very slow process, but the one benefit is the employer is obligated to pay the fees associated with the perm application. So that's a bonus that the applicant is not having to incur those expenses on his or her own. With most self-petition green card processes, which we'll get into on the next slide, I'll provide an overview of those. Um, that is the financial responsibility of the applicant. There are some exceptions to that, but certainly I would say with EB1, extraordinary ability sponsorship, that almost always is the applicant, the employee's responsibility. Um, with the EB2 categories, sometimes exceptions are made by employers to help financially support and pay for those processes, but typically it's in lieu of the perm application. So if a candidate were to ask the employer, instead of your standard, um, cost expense coverage for the perm application, would you support paying instead for a physician national interest waiver? And sometimes those requests are granted. But I just wanted to highlight that, one does need to consider the whole question of cost when it comes to this, because particularly EB1 filings, can quickly add up to being over $10,000, $10 to $15,000 with all the various government filing fees included. Now, the baseline I-140 application fee is $715 plus a $300 asylum program fee, plus a nearly $3,000 premium processing fee, plus the legal fees. They're very extensive filings, and a lot of time needs to go into them. So, financially preparing yourself for, these potential self-petition green card filing undertakings is something important to consider. So moving on to the EB1 self-petition filings. EB1 is the top of the pyramid in terms of it being the most difficult to qualify for based on one demonstrating they have extraordinary ability. When you look at the regulations, the EB1 category criteria essentially lay out that the applicant has either won a Nobel Peace Prize or an equivalent award or meets a minimum of 3 out of 10 criteria, and typically that's a bare minimum of 3, and it's reviewed based on a totality of the circumstances standard. So this category really is designed for someone who is a leading expert in their field of endeavor, who can demonstrate that through objective supporting documentation, um, and not simply, thinking that just scratching off the surface of 3 of these criteria is going to be sufficient to qualify for. So the beauty of the EB1 category being at the top of the preference categories is that typically it's current, the priority date is current, meaning once you are approved for it, you can immediately file for adjustment of status. You can either do it at the same time if it's current or wait till the I-140 for the EB1 request is approved and follow that up with an I-485 adjustment of status application once you get that peace of mind that it's been approved by USCIS. So having the category be current, which typically it is most significant and important for individual nationals of India and China who would otherwise be subject to incredibly long backlogs, meaning wait times in the EB2 category that could be over 10 to 12 years. So qualifying for EB1 is incredible if you can, because that essentially erases that, 10 plus year wait to be eligible to file for adjustment. But it is no easy feat to qualify. And as I mentioned on the last slide, it's not, it's very costly as well. So I wanted to highlight what some of the what all of the criteria are, in the hopes that those of you who think that maybe perhaps your CV one day could support such a filing can work towards building up your credentials to strengthen the potential of being able to pursue this category in the future for the benefits that I just described. So one of the first criteria is receipt of nationally or internationally recognized prizes or awards for excellence in your field of endeavor. The main highlight here that I wanted to make is that it really does need to be a nationally or internationally recognized prize or award in your field of endeavor. I see a lot of trainees wanting to apply for EB1 who have been granted, you know, awards, let's say within their academic institution for best resident, or, outside that context for like a poster presentation award. But really, the receipt of the nationally or internationally recognized prize or award, it needs to be for a highly competitive national or international level prize or award, with documentation being provided of the selection criteria, the nominating committee composition, who grants the award, what are the competitive statistics, how many people will apply for this, what percentage are granted the award? Is there a monetary function? But all of that needs to be very carefully detailed in order to qualify for that criteria. So this one is more uncommon for applicants to be able to meet. Not to say, I haven't seen it. Applicants accomplishing, you know, the level that USCIS is looking for in connection with this particular criteria, but it is challenging. The next criteria is memberships and associations. in the field which demand outstanding achievement of their members. So here, documentation of again, similar to kind of what I just described. What are the criteria for selection onto this, into this organization? What type of evidence of outstanding achievement? What was the basis for someone being invited? And it's an invitation to the organization that only, individuals who essentially have accomplished some type of outstanding achievement would qualify for that invite for. So it's not for a professional organization for a particular like subspecialty where, or not even a subspecialty, but just for a particular, your field of expertise that other physicians in your area can apply to become a member of the organization. That is not what this criteria is getting to. So again, this one is pretty rare for applicants to qualify under. But certainly, again, we see individuals meeting this one occasionally for sure. The next criteria is published material about you in professional or major trade publications or other major media. So here I wanted to focus on that the published material needs to be akin to a news article specifically referencing the applicant's name, calling them out individually for their work. It cannot just be like I see this a lot, like, in a medical journal, like, an abstract, like a reference to an abstract that, the physician was, like, a collaborator on, etcetera. This really needs to be an individual, um, media coverage about someone's particular work, in order to qualify under that criteria. Again, one that's pretty, I would say, uncommon, but certainly we've, again, seen it in the past. The next one is a judge of the work of others, either individually or on a panel. This one is very common, and most applicants can qualify for this one, unlike the prior three that I mentioned are a little bit more uncommon. So for this criteria, the way that most applicants meet this is by accepting invitations to act as a peer reviewer of a medical journal, and or an invitation to serve on the editorial board. So the more invitations and actual journal reviews that an individual can conduct and document that, the better in terms of qualifying under this criteria. But this one is very doable, so it's something that everyone should consider if you are contemplating going for an EB1A filing. The next criteria, again, is another one that most applicants try to qualify under, but it's exceedingly it receives a lot of pushback from USCIS because it can be subjective in terms of original scientific related contributions of major significance in the field. And so, here USCIS does like to push back on what constitutes it being original and or major significance in the field. So it's really important with this criteria to try to objectively demonstrate why an applicant's work is of major significance in the field. One of the ways we do this is by essentially working with the applicant to obtain recommendation letters from leading experts in the field within the organization that they're currently working for, but also externally at independent organizations detailing what major contributions they have made to the field, why they are major contributions, why it is original work, etc. We also, supplement that by showing kind of Google Scholar reports that an individual applicant's work is being highly cited by other experts in the field. Sometimes in the rare occurrence when someone has a patent and or has developed a certain um, medical tool or um, device that has that been picked up by, let's say like the pharmaceutical industry or private industry and adopted, that can be incredibly helpful, powerful piece to qualify under this criteria. Um, so that is one that most applicants do try to qualify for. The next one is as well authorship of scholarly articles in professional or major trade publications. Here being first author is stronger evidence qualifying under this category, but it's not necessarily required. But I would say, the more first authored papers and the higher the impact factor of the journal that the scholarly articles are being published in, the stronger an applicant qualifies under this particular criteria. But normally there is not much pushback from USCIS as it relates to this criteria. The next criteria is performance in a leading or critical role in distinguished organizations. So, for those applicants working for a highly distinguished institution, demonstrating evidence of that, and also so that piece is easy. Like, let's say it's a Mayo Clinic or something. That we, as the attorney, would present documentation attesting to the distinguished reputation of the organization. The piece that requires a little bit more work is the applicant's performance in a leading or critical role within that organization. So there, typically a letter from a department chair is sought after, really detailing what the applicant is doing um, for the organization. Why is it critical? Going into depth about not just the job duties of the particular position, but the research. Why, the grant funding. Why is this of absolute importance to the organization? So this one, we do often see applicants arguing that they meet this specific criteria. The next one, the last one that I'll go over is commanding a high salary or other significantly high remuneration in relation to others. This one's less common. A lot of the times we're filing EB-1As for trainees because they really want to get a green card to then go on to maybe subsequent fellowship training and not have to deal with visa sponsorship restrictions and limitations. So obviously trainees are not being paid great and high, a high salary or remuneration. So this is a category that most, I think, wish they could file for and argue for that they qualify under, but don't. But certainly, someone who is a specialist, who is functioning as an attending, who is being paid significant compensation, can go for that category. Okay, so moving on, I'm going to kind of buzz through the EB2 category because I want to leave enough time for Q&A. EB2 category, obviously falls under EB1. So historically, with the visa bulletin that controls green card wait times, for nationals of most countries, EB2 used to be current, but now is not. So even for most countries, there's a 1 or 2 year wait time associated with the EB2 category. Then, of course, as I've mentioned throughout, the kind of unjustly long wait times that Indian nationals and Chinese nationals are subject to, you're looking at 10 to 15-year wait time for EB2. So that's something to consider when thinking about self-petitioning under this category. there's two types of self-petitioned EB2 category filings that one can consider pursuing. One is a national interest waiver. And, I wish they would have created different names for these because they essentially sound like the exact same thing. Like they should have thought of something to differentiate them a little bit better because it gets really confusing for people, I think. So, first, national interest waiver petition. This is for applicants who possess an advanced degree, which obviously all doctors do. So that's easy criteria to meet. Um, it's really the second criteria that the work that the applicant is doing is of substantial merit and national importance that can be difficult to establish. So this category is really designed for someone who is doing research typically and working on something that would be considered of national importance. I- Applicants who are just working clinically in their designated, within their designated organization, and let's say even are providing critical services to medically underserved populations, um, while that's in the national interest in all of our minds, sometimes there's pushback whether that work is national in scope based on kind of the limited geographic area that the clinical work is being conducted in. So the filings that do better, I think, for NIWs are, um, working on important research that, cancer research, infectious diseases, whatever it may be, that a solid argument can be made is of national importance for everyone in the U.S. We are seeing some under the current administration, maybe some directives of what we would consider is in the national interest not being considered by the adjudicators to be in the national interest. So, physicians who are working on certain underserved populations and equity. Are we good? Yeah. Okay. Great. Um, there is some political um, nuances and impacts of what's considered in the national importance right now, because it is a federal agency and the adjudicators are kind of being directed. But so it's getting a little bit more wishy-washy under this category in that respect. But certainly is a good category for someone to consider filing for, and if you think you kind of are doing work that's of national in scope and importance. The other type of EB2 self-petition filing is a physician national interest waiver. This sometimes dovetails nicely with a J1 waiver 3-year commitment period. So with a PNIW, it's a 5-year commitment in a medically underserved area. And for an applicant who's already getting a J1 waiver and committing to 3 years, if they sign on for an additional 2 years, they could qualify to self-petition under this category. And they may want to, particularly if they're from a backlog country, because they could go directly to filing an I-140 petition, seal in their priority date faster than they would be otherwise with the perm application for the reasons I described earlier. And so, definitely something to consider strongly, I would say, for someone who is from a backlogged country. For others who are not, their goal is to get a green card as quick as possible. So even if you're doing a J1 waiver and you're required to commit that 3 years of medical service, then probably a perm application. Oh, I think there we go. Thank you. Um, A perm application, even though it's slow, if it's started while you're completing your 3-year J1 waiver commitment and it's starting right way, that could be a faster route to a green card than the PNIW because you have to wait a full 5 years before you're eligible for the green card under a PNIW. So I just highlight, this being more of an attractive option for someone who really is looking to get an I-140 approval fast, maybe to file an H-4 EAD for a spouse or whatever it may be, and who's already locked in to a 3-year J1 waiver commitment. Um, and either doesn't have the support of their employer to file a perm, or it's just, this meets their goals more, to get that quicker priority date and the H-4 EAD, something to definitely consider. So, that covers the self-petition green card options that I wanted to, provide an overview of. So let's open it up for Q&A.
Yeah, thank you so much for that timely, informational, and practical presentation, Attorney Hopwood. So, the immigration journey for most of us have been quite stressful, and many of us have lost sleep over that. So, compassionate and knowledgeable individuals like you, Attorney Hopwood, has made the journey a little less overwhelming and a lot more hopeful for us. So thank you so much for doing this, despite not feeling your best with all the sore throat and everything. We have a couple of questions in the chat. So the first question is about the wait time that you're seeing for Indian nationals for the EB1 self-petitions within US currently. Would you be able to comment on that?
Yeah, so if
Um,
Attorney Hopwood, you're muted. Okay.
uh-huh.
oh, I didn't touch it. Weird. Am I good?
Yes.
Oh, okay. Thank you. Um, so that's a really hard question to answer because, to be honest, processing times are all over the map. So with premium processing, one could obtain an I-140 approval within 45 days with premium processing. Um, but then, in order to file for adjustment, priority date needs to be current, and then filing for adjustment of status, the I-485 application is not eligible for premium processing. So typically we see I-485s being adjudicated within about a year of filing. But that also is dependent on whether someone could file their I-485 based on what chart on the visa bulletin they can file their I-485 based on, and then whether it's subject to retrogression, and then, which can really impact the total processing time and when a green card will be received in hand. And the other thing that we're seeing become really common is the requirement for now interviews for employment-based and or self-petition green card filing. So the interview requirement is also going to impact processing time. So I'm sorry, it's just not something that can, a clear answer can be provided given all that uncertainty and all those moving parts.
Got it. Um, another question is about residency, and can residents like apply for like EB1 or 2 during residency if they are on the H-1B visa, or do they need to like complete their training for that?
Residents on H-1Bs can definitely pursue these self-petition green card options. EB2 national interest waivers used to be a lot easier, and I've seen trainees even get approvals on their own as of a year or two ago. And now if you look at the adjudication percentages of USCIS, um, the denial rates are going up, and it's becoming more difficult to qualify for, even though it's, EB1 is even higher threshold above that. So if the CV supports whatever category that someone is seeking to file for, they can certainly do that with, during their residency training. So that's the one caveat, having the CV to support it. The other thing that I think is important to mention is for J1s, it's more complicated to self-petition for a green card because J1s are not dual intent visas. They're single intent visas. So you cannot, it can become problematic once you file an immigrant visa petition, which the self-petition green card filing, the I-140 petition is. If, let's say, you need to go and whether get an extension of the J through ECFMG, and they're aware that you filed for something that's has immigrant visa intent, and also at the U.S. Embassy level, let's say if you needed to travel internationally and obtain a new J1 visa stamp before returning to the U.S., having an I-140 approval and or, even thinking about, filing for lawful permanent residency can have incredibly negative impacts in the J1 context for that reason. So something to be careful of there and very carefully consult an attorney, regarding what's kind of permissible, what's risky, what's not, what you should avoid depending on your particular circumstances and the timing of where you're at in your training.
Sure. Another question is pertaining to like ACP. ACP offers like FACP, like the fellowship in ACP, and would that count towards like being part of a national reputable organization under EB1?
To be honest with you, I don't know enough about that to say whether that requires outstanding achievement to be invited as a member of. You guys probably know better than me. That has not come up yet with filings that we have prepared. So sorry.
Got it. Another question is from Lydia Dandas. Her spouse is on EB1C with an approved I-140, and she's going to be starting her training as a resident physician soon. And her being a physician, is that helpful in expediting the process?
Um, well, I would need more details, unfortunately. Like what type of status would she be starting her training on? Like the fact that I mean, I guess to simplify, if she's filing as a dependent of her spouse for green card purposes, which is what the question led with, he's filing an EB1C green card. That filing really just pertains to his credentials to qualify for that category, and nothing that she was doing professionally would impact that filing because he's the primary applicant. So that's what USCIS is concerned with, his credentials and not hers.
Got it. Okay. Another question from Johannes. It's on this person is currently on F1 visa and they'll need to change their status to J1 visa to begin a residency. Would it be possible to apply for a change of status from within the U.S. or would they have to like leave the country to complete the process?
Typically, it's not possible, and consular processing is required, unfortunately.
Meaning he has to leave the country.
Mm-hmm.
Okay. Um, I think we are at time, and so thank you so much.
Yeah, you're welcome. No, I would say just with that last question that, checking with the House Staff Office, like the Graduate Medical Education Training Program, like it kind of depends on the policies in place at the time of filing. So I just wanted to put that caveat there that, that in terms of whether someone's eligible to file for a change of status, like really depends on a lot of specifics. But generally speaking, um, individuals are required to consular process it in that context due to timeline considerations, et cetera. It's just not feasible to do the change of status. But go ahead. Sorry.
I had a couple more quick questions. There are some physicians in this group, especially physician leaders, who have been tasked with writing letters of support for EB1 candidates. Do you have any kick pointers for them while we write those letters?
So typically the way the process works is the applicant normally drafts like a template letter. Um, and so the advice I would have for leadership who's being asked to support and sign these letters is to really try to add your own spin and details to the letter. Because what often happens with these applications is that the recommendation letters start looking like cookie cutter kind of mirror images of each other, which really weakens the strength of the letters. So the more detail that you can add to the letters, the context that you know the individual and why, they've risen to the top of their field compared to their peers, and why their work is original and of major significance in the field. Like really delving into the whys and the support to really build up those assertions is the important piece, because sometimes it's just those blanket statements like, this applicant is extraordinary, but there's really not the meat and the support to back that up with specific examples of why. So that would be my main suggestion there. Really try to go in depth as much as possible, provide examples, and add to it with your own judgment and opinion.
Thank you so much, Attorney Hopwood. This is wonderful, wonderful. And thanks for giving us those exemplary, important points to consider, and including those letters, because that is, and surprisingly, I had two people who I wrote letters for, and both of them, the FACP was one of the reasons that they were asking for. So it's something interesting and to learn from your standpoint. And thank you so much with all your sore throat and everything. It's such a phenomenal job. I hope you get better soon. A lot of warm hugs. There are a lot of
Forward to join
physicians
event
who
tonight.
reach out to any.
No, my pleasure. I'm glad I could be here for you all.
Yeah.
Okay. Bye-bye.
Bye. Thank you. Thanks, everyone.